So yes, yesterday we were discussing about Grotius's take on natural law. So essentially, we were discussing this conflicting idea that has been there for a long time about human nature. Some say that human nature is selfish, that they're motivated purely by self-interest. Uh, but then there is this other view that human beings are naturally sociable. Okay, now now if you were to take either of these two as the only nature of human being, then you come to different conclusions about what is natural. Okay, so that's what creates problems. So it's quite possible in reality that some people are purely motivated by only self-interests. Okay, are never able to think in terms of a community, in terms of a group, in terms of a society. Well, such a person will have tough time, living in a society, because after a point of time, being too selfish, he will be avoided by the members of the community, and then such a person will have to face, suffer some consequences in life. But then, other than that, what I personally find is that yes, people are driven by self-interest, in the sense that most of the things that we do in our lives are for the sake of betterment of our own self. But at the same time, to what extent are you willing to go to aggrandize your own power is a question. Okay, that remains. In fact, that is what most of these thinkers struggle with. Okay, what is it okay for individual to sacrifice for the sake of the group? Okay, so as you know, the idea of natural rights hasn't yet arrived, although you see some semblance of that idea in the works of Hugo Grotius. But then the idea of natural rights only emerges in the works of John Locke. Yeah, so those idea of natural rights are quite individualistic, whereas this idea of natural law that we are studying so far are not that individualistic. They are duty oriented towards a group, okay, towards a society, towards the city state, etc., etc. So now, as we were discussing, okay, they come to different conclusions because they think of different things as human nature. So yesterday we discussed that Stoics thought that humans are reasonable. Okay, they are also sociable. So there is this thing called universal brotherhood that creates some sort of social solidarity, and we are to act so as to protect and uphold that social solidarity. Okay, so this is the general idea. On the other hand, Carneades takes a different kind of position. Okay, he doesn't believe that human beings are inherently social beings. Okay, so he doesn't focus on maintenance of social order as something that we ought to do either. He would rather focus on individual and their own self-interest. So he would say that if you work for the benefit of all, for the collective, for the society, then you are the greatest foolish. So if you remember the quote, which is from the reading that I had shared, in which Grotius essentially is referring to Carneades and then saying that men have established jura, law essentially according to their own interests, okay, pro utility, what is of utility to them, which vary with different customs and often at different times with the same people. So essentially saying that there is no universality in law, it varies from time and place, because those laws are purely for the promotion of interest of self. Okay, so there is no natural justice. All men and the other animals are impelled by nature to seek their own interests. So either there is no justice, or if there is such a thing, it is greatest foolishness. Okay, so essentially they are saying that there is no such thing called justice. So in a world of this sort, there will be constant chaos. One will always be fighting other for the sake of personal aggrandizement. Okay, but then what would Carneades say to that? You will say that there is nothing wrong in fighting for your own well-being, okay, fighting for your own benefit. because there is nothing called wrong or right in nature in itself. So do whatever is convenient for you. So if at all law exists, it's for the sake of, prudence, okay, not for the sake of justice, okay, only to the extent that it is required for, your own personal benefit, okay. The moment you have something to gain personally, at the cost of society without hurting yourself, then there is nothing wrong or right about it. So this is the kind of, idea that that Carneades held, okay. But Grotius will not have it, okay. He does not believe what Carneades says, okay. He doesn't believe that it's in the inherent nature of humans to be selfish, and hence there is no right and wrong. Grotius, we already discussed the history, the background already, that he felt the necessity of a law which is higher to the laws created by, for example, the sovereigns, because this has to be binding on them so as to regulate their behavior, especially in the case of in the relation between two sovereign states, okay. And we discussed that this theory is very important in case of international law. Otherwise, there is nothing that regulates the relation between sovereign free states, okay. So, for example, one of the sources of international law, as you know, is treaties and conventions. Those are nothing but agreements between two sovereign states, okay. So if we were to follow Carneades' approach, so at any moment that agreement goes to the disadvantage of the one of the parties, they will just back off of it. So that's going to create further problems. So Grotius has to come up with a philosophy that says that even when something goes to your, something may affect you in a negative way, but because you have made a promise, promises ought to be kept, okay. Why is that? So sanctity for that is to be traced from something higher, that is the natural law. So hence he focuses on the human sociability rather than selfish individuality. So he says that among the things which are unique to man is the desire for society, appetitus societas, okay. So humans have a desire for society, that is for community with those who belong to his species, though not community of any kind, but one at peace, say, for the sake of peace, because it is very essential, and with a rational order, pro sui intellectus mod ordine, something that you know through your intellect. Therefore, when it is said that nature drives each animal to seek its own interest, we can say that that is true, that this is true of the other animals and of men before he comes to use that which is special to man. So he's saying that we do not deny that humans, like other animals, are also driven by, self-interest, okay, this desire to seek own interests, okay, but only till he comes to know of the, of that which is of special use to men. That if you are driven only by self-interest, then it causes some problems, okay. So you also need community, you also need unity, hence the idea of human solidarity. I think some of you have taken that as a project that you are going to work on. So finding justification for human solidarity is very problematic, and sometimes it leads to extremes where individuality is completely subsumed into community, and then individual existence does not exist. Everything is for the community. And on the other extreme are the extreme versions of individualism, where the community does not exist. Everything is all about selfish desire. So for the whatever you think is good for yourself. So you, on the one hand, you have extremes like libertarianism. On the other hand, you have extremes like communism. So anyway, those are again more more of an application when it comes to economic matters, but also in other matters. So anyway, we have not yet come to those extremes yet. For now, all that Grotius is trying to do is how to preserve a peaceful social order, okay. That's the biggest task that he has at his hand, that how do we avoid the barbarity in wars, okay, how do we avoid chaos in the dealings of sovereign states, okay. So he needs that. So to establish a peaceful social order, he is focusing on the human sociability. So thus he says that the maintenance of social order, which we have roughly sketched, and which is consonant with human intelligence is the source of law, properly so called. Okay, so law exists for the sake of maintenance of social order. So if any law goes against that, it's violating the natural law. Okay, so all law has to work towards maintaining social order. But there are lots of questions that emerges with respect to this. We will not go into all that for now. Okay, so he, based on this premise, he finds out something, some very specific aspects of that law. Okay, so to this sphere of law belongs abstaining from that which is another's. So from here you know that he is talking about some kind of private property. So he is talking about some kind of respect for private property, and that's very much part of that natural law. So abstaining from that which is another's, something that belongs to other, thou shalt not take it. Okay, so that's the idea of private property, I see. So some idea of that is emerging. So the restoration to another of anything of his, okay, which we may have received from it. So if you have received something from someone that belongs to someone, okay, you are to restore or return it back to that person. Okay, so think of it. Okay, these are very simplistic things for us to hear maybe now, but imagine the kind of state of nature that, for example, Hobbes was talking about. Hobbes' law, well, not Locke as much, Hobbes was talking about. Okay, if that were the case, forget about the social contract. Okay, if that is the kind of society you live in which everyone is driven only by selfish desire, so this is what natural law can do there. Okay, so it tells you that you shall not take what belongs to others, and if you do take, you have a duty to return it back to them. Okay, so even now the law of property is all about these only. Okay, then the third one is the obligation to fulfill promises. This is very important, as I told you. Okay, the entire contract law, okay, is based on this of fulfilling promises. So there are offers and acceptances, there is consideration. Those are nothing but promises, okay, and counter promises which are made, which ought to be kept. Okay, and law basically enforces such promises. Okay, so this is what he is talking about, another important aspect of it. Okay, that obligation to fulfill promises. If you have made promise, you ought to fulfill. Now think about this at the international level. Okay, so when two countries enter into a treaty or covenant, okay, they ought to stand by the promises that they make in those treaties and covenants. Okay, so this is very important for him, and the source for it is in natural law. So then the making good of a loss incurred through our fault. So if you have caused someone else some loss, then you have to make good that loss that you have caused. Okay, another aspect of it. And then inflicting penalties upon men according to their deserts. Okay, so it's the theory of punishment that he's talking about. So someone who has done something, okay, has to be met with some kind of punishment to the extent that they deserve it. Okay, so these are the different aspects of that law that he has been talking about. So if you maintain all this, then there will be maintenance of social order and peace. Okay, so there are certain minimal conditions or values which are required to be protected. This is something that you can derive from all the rules that we have just discussed. Okay, that some sort of security of property has to be there. As I told you, okay, you shall not take what belongs to others. So some sort of security of property has to be there. Okay, and good faith has to be protected. Okay, that when you enter into a contract, when you promise something, it has to be kept. Okay, so good faith has to be protected. There has to be fair dealing, okay, and a general agreement between the consequences of man's conduct and their deserts. Okay, so you get what you deserve. So these minimal conditions or values that we just talked about, you can derive it from the rules that we have just discussed, which are within the sphere of the kind of law that he is talking about. So yes, that's what his idea of law is. So from this we can come to the conclusion about what natural law exactly is. Okay, so he gives you a very specific definition of natural law. This is not too different from the others, as you will see, because the approach is more or less the same, of the same type. Okay, so he defines natural law like this: the law of nature is a dictate of right reason. Now here the law of nature that he's talking about is not what Galileo or Newton was talking about, not the physical laws of nature. Okay, he's talking about natural law as we understand. So he's saying the law of nature is a dictate of right reason, as the Ciceronians would believe in, which points out that an act according as it is or is not in conformity with the rational nature, okay, has in it the quality of moral baseness or moral necessity, and that in consequence such an act is either forbidden or conjoined by the author of nature. For him it's God. Okay, however, as you remember earlier we discussed, because he is an anti-voluntarist, even if the God didn't exist, this law of nature that he is defining would nonetheless exist, because this law does not arise from the will of God, but from the fact that God is perfectly rational. So God will not be able to do something that is against the law of nature. Okay, so this law does not arise, as he said, sic volo sic ibeo, of God or man, does not create obligatory nature of the law. So will of God or man does not create the obligatory nature of law. It comes from the very fact that this natural law is reasonable. Okay, so that's the definition of natural law that he gives. Okay, it is the dictate of right reason. Okay, it tells you what is the right thing to do. Okay, so your act will be judged based on, whether it is in conformity or against the said law of nature. Okay, so the farther it is from the law of nature, the more morally base your conduct is, the more close it is to law of nature, the more necessary this moral conduct is. So this is essentially how he defines natural law. So that's it. This is something that he, as I told you earlier, this idea of natural law that he creates, you can find it in the book De Jure Belli et Pacis, in his prolegomena, the introductory part. That's where he develops the idea of natural law, and after that he goes into laying down his entire law relating to war and peace. Okay, so because we are concerned only with natural law, I thought that I will just end it there, but then I would just introduce something that he has worked on. Okay, and that is important, and you will study this more specifically in humanitarian law later on, IHL, but then also some part of it also in international law. Okay, so essentially there are two kinds of laws that you find here. Okay, where this idea of natural law becomes applicable. Okay, one is jus ad bellum, okay, and the other one is jus in bello. Okay, so jus ad bellum essentially is all about what is a just war. Okay, so when is it justified for one to get into a war, for a country to get into a war? Is war completely proscribed, or are there situations when war is justifiable? So his theory becomes a tool for identifying this, for answering this question. Okay, so he does not say that war is completely proscribed, because even if you are acting in accordance with the laws of nature, there is no guarantee that others would. Okay, so if someone is attacking you and then you're saying that I will not get into a war, that will be foolish, isn't it? So there are situations where his idea of natural law allows you to enter into a war. Okay, so that is for the right cause. Okay, that is for the pursuit of a right. Okay, so when does that arise? So for example, in self-defense, okay, when someone attacks you, you have the right to defend back. Okay, using force, of course. So that would be one case of just war. If someone has taken your property, okay, or your territory has been conquered. So in that situation, he would say that a war can be justified, and sometimes even to punish some other country. Okay, if some other country has done something which is not acceptable, what are those? We will come to know. Basically, states that grossly violate principles of natural law. Okay, in those situations, you can enter into a war to punish that country. Okay. But what is essential is that there should be a declaration of law, declaration of war. Okay, war. You do not just get into a war. You have to declare that you are in war with the country, and then you get into that war. Okay, so when you enter into a war, there has to be just cause for entering into the war. Okay, and there has to be right intention. You cannot enter into a war for unjust cause or for wrong intention. Okay, so you can, for example, you don't have to wait until someone attacks you. Okay, if you anticipate that someone is going to attack you, you can go ahead with anticipatory self-defense. Okay, so but that is to protect yourself. Okay, to that extent it is allowed. So preemptive strikes and self-defense are allowed. Okay, and then there are other situations also in which you are not a threat. Okay, but then it may be just for you to enter into a war. Okay, those would be, for example, if a country, if the leader of a country, or if a country, is involved in genocide. Okay, or other war crimes. Okay, crimes against humanity or ethnic cleansing. These are basically the modern jus ad bellum. Okay, so in those situations as well, there is a responsibility for you to protect, others who are not within the territory of within your territorial limits. So in such case also, war could be a just war. So states have the right to punish gross violation of natural law. So in all these cases, what we can say is that other states are violating, are grossly violating the natural law, and hence you have the right to, you are justified in entering into a war. Okay. So yes, that is the case. So one cannot say that a state will not say that, okay, I am protecting, I am only protecting, I'm only responsible for the part of the population. For others, I don't care, so I'm going to annihilate them. So for example, so that will be problematic. So when Hitler was trying to kill of Jews, okay, that would give a justified, a reason for other countries to declare a war on Nazi Germany. So these are the situations in which we could say that there is a just war. Another factor that you need to keep in mind is that before you declare a war, you have to think about how likely is it that you will win the war. If the chances that you win the war is very less, then there will be serious damages, harm that you will suffer. In such situation, that should be a factor in not getting into a war. And then what kind of damage that can you cause? Okay, so the collateral damage that happens has to be proportional to the necessity of the force that you that you need to exert here. Okay, so the force that you exert should not be more than what is required, so as to limit the collateral damage that can happen in a war. And finally, war should be the last resort. Okay, it should not be the first thing that you do. So if you can create other diplomatic pressures through other means, if you can avoid getting into war, avoid it. So war should be the last thing that you take resort to. So that's the idea of jus ad bellum. Okay, and these ideas that we just discussed about are derived from the idea of natural law that Grotius is talking about, and of course how it evolved subsequently. Then another aspect of this law is jus in bello, also known as international humanitarian law. So this is basically when the war is already there. So once the war has started, it should be the attempt to restrict the damage, the harm that war causes to individuals. Okay, so this in fact is the law relating to how to conduct war. Okay, so I'm not an expert in all this. Okay, I'm just talking about this from the perspective of an external. Okay, in the sense that I'm only concerned about the philosophy, but to the extent that it tells you what the outcomes of this philosophy are, I think it's necessary that you know. But you will of course study this in greater detail in other subjects. So yes, jus in bello is the law relating to conduct of war. Okay, how to conduct war. Okay, so there are certain restrictions which are imposed. Okay, so too much force is not to be used. Okay, only do things which are necessary for the end of to attain the end of war. Okay, so you enter into a war for a particular purpose, do the things which are necessary only for that end. So for example, in war, two sovereign countries enter into war, they can, for example, use carpet bomb and completely destroy the civilian population. Okay, but that is prohibited. Okay, if you are to only target the establishments which are necessary so as to end the war as soon as possible. Okay, so do only things which are necessary. So harming the non-combatants, okay, civilians are proscribed. Okay, and of course once a soldier surrenders, they are to be treated in a certain way. Okay, so and then who we call prisoners of warfare. Okay, they are also to be protected. So once they have been caught, okay, the soldiers are caught. Okay, they become prisoners of war. Now they are not to be ill treated, they are to be protected, because they were only fighting on behalf of a state. Now you have caught them, they are humans and they are to be protected. Okay, and then ultimately no excessive force. Okay, only moderate force should be exercised so as to avoid excessive harm or damage. Okay, so this is not the entire thing. As I told you, this is just introductory things that I thought you guys should know of. Okay, so in the work that he had done by the name De Jure Belli et Pacis, this is how he develops his entire idea of natural law. So he develops his idea of natural law in the Prolegomena, and then applies that idea of natural law in law relating to war and peace. And that's a very important piece of work. And subsequently, international law evolved and became a very strong branch of law altogether that you will study. Anyway, I'm not going to go into all that. But after Hugo Grotius, what had happened was that the idea of natural law gradually lost its, not just after him, after a few more, years, the idea of natural law, okay, as it was understood then, gradually lost its, attraction, lost its sheen, okay, because of another way of, thinking, another way of knowledge that had emerged. Okay, apart from that, positivism was also emerging. Okay, so positivism became a serious threat to the idea of natural law that we discussed so far. Okay, which is now considered to be very arbitrary, in the sense that anyone who says that okay, this is what natural seems to be natural, there is no agreement about that. Hence a more neutral, value neutral, positive law had emerged. Okay, but then positive law also received this serious threat, setback during the Second World War, and then subsequently natural law again re-emerged. Okay, so that's the status of natural law for now. So in the next class we will take up John Locke. Okay, now John Locke is a philosopher who is not dealing directly with natural law. He's concerned more with natural rights. Okay, so that we will discuss, and then we will take up John Finnis, and with that I think we will be done with natural law. But there will be certain other philosophers that we need to discuss after that. Those are, for example, Immanuel Kant or John Rawls, who are also important, but I will take them up only later when we discuss about justice. So that's it for today.